Today is Tuesday, March 11, 2014. Time is 10 a.m. It's my pleasure to call the order of State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Bombers. Ms. Mosley, will you call the roll, please?
Robert Helms.
Present.
Wayne Hinkle.
Present.
David Neal.
Here.
W.T. Patterson.
Here.
Jane Gray Sowell.
Here.
Robert Starkey.
Here.
Anita Taylor.
Here.
Mr. President, all board members are present.
Thank you. We now have a quorum. We'll continue the meeting as planned. We'll now look at the agenda.
Motion to adopt the agenda as
Second.
presented.
Have a motion for Mr. Hinkle, second by
Me, David.
David Neal.
David, sorry, Neil. We will continue. We have a formal hearing, and we will now turn the meeting over to the administrative law judge.
All
I
right, thank you,
would-
Mr. Starkey.
I think the battery's dead in the oven.
Today is Tuesday, March 11, 2014, at 5 p.m. in the afternoon. It's my pleasure to reconvene the Board of Funeral Directors and Bombers. We're going to kind of go out of line just a little bit because we've had some folks waiting all day here. And so we'll go on and here, take care of the individual license at this time.
Mr. President, you have one person, Mr. Dennis Ray Murphy of Memphis, Tennessee, who is applying for a funeral director and embalmer license for reciprocity. Based on the application, the board may, among the other statutes and rules, specifically examine TCA 62-5-317 and make a determination of whether the applicant meets the requirements for licensure. Since I moved the mic, Mr. Murphy, if you don't care, you might just sit down. I'm sorry, I moved that handheld mic, so there's no recording from that right now.
Well, everything is okay except that number 2, correct?
Yes, sir, the answer to the question is the only,
That's correct.
the answer to question,
This order.
question 2, yes.
Question 2.
And there's an explanation, a narrative from him that's 2 or 3 pages into your folder there.
I was trying to read it, but,
Personally, I feel
Dennis?
that, I feel the explanation
yeah.
satisfies.
Tell us what happened. Tell the board what happened.
I've actually got the narrative right here if you'd like for me to read it to you, because since you all weren't able to read it. It says, my name is Dennis Murphy and I'm applying for a Tennessee Directors and Bombers license. On approximately October of 2010, I was arrested for disorderly conduct. The reason being there was a problem with one of our neighbors who was definitely a drug addict. He had exposed himself to my 13-year-old daughter, and when I called the police and they came out, I lost my cool and said a few out of the way things to the neighbor out of anger in front of the police. We were both taken to jail. I was released the same night. I had court the next day and paid all of my fines. He failed to appear, and a bench warrant was issued for his arrest. There's nothing more that I'm proud of when it comes to my family, and I felt I had to do something to protect my daughter. I know I should not have said a word at all, and I hope that doesn't influence the decision as far as my professional work ethics. My letters of recommendation speak for the professional that I truly am. Sincerely, Dennis Murphy.
Well, it's been taken care of, and ain't been in more trouble since then.
When I said I couldn't read it, it's not because of the documentation that you submitted, it's because of my eyesight. Okay?
I understand.
Motion to approve.
Second.
I have a motion for Mr. Hinkle and a second from,
Don't matter.
okay, David Neal. Any questions? All those in favor?
Aye.
Any opposed? Motion carries. Congratulations.
Thank you.
Sorry you had to wait all day for that.
Can you smile now?
Mr. President, I would suggest to you that you do the legal report next. I think we have some members of the audience probably waiting on that. If
Okay.
that's, even though they won't be speaking, I think they want to observe something in that.
What was it again? I'm sorry.
The legal report.
Okay, the legal report. Okay, we'll ask Mr. Vinton. O'Donnell.
Thank you, Mr. President. Complaint number 1 is case number 2013-024301. Number 2 is case 2013-024302. On November 26, 2013, a field representative conducted an inspection of the respondent establishment. The funeral director's license and embalmer's license for respondent number 1 expired on October 31st, 2013, and was not renewed until November 5th, 2013. During that time, respondent number 1 was an employee of respondent number 2 and served in the capacity of funeral director for one deceased family. All of this while in possession of an expired funeral director's license. In this case, we received no response from the respondents. As far as the prior history, respondent number 1 has no prior complaints. Respondent number 2 has 6 prior complaints. And for respondent number 1, we're recommending a consent order with a $500 civil penalty, which already includes $250 for no response and authorization for a hearing. And then for respondent number 2, we're recommending a consent order with a $500 civil penalty, which also includes $250 for no response and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Ms. Taylor and a second from David Neal. All those in favor?
Aye.
Any opposed? Motion carries.
Number 3 is case 2013-024041. The complainant's father passed away on October 18th, 2013. And prior to his death, the family met with hospice to make final arrangements, and a gentleman by the name of Gary, whom none of the family members actually knew, informed the family that he had legal documents reflecting their father's final wishes to be cremated. Once the decedent passed away, the coroner and this individual by the name of Gary showed up with the document and a blank piece of paper with their father's signature. The next day, the complainant contacted the respondent establishment where the decedent's body was located for several days, also where the decedent supposedly had a burial policy. After many attempts at contacting the establishment, the complainant spoke with an individual who was very rude and informed the complainant that the decedent was in a freezer currently. The employee then told the complainant that the complainant had no say over her father's cremation, so the complainant then contacted another local funeral establishment and asked them to take possession of the decedent's body. They tried to contact the respondent funeral establishment again, and this time the respondent informed them that there actually was no burial policy with the establishment, but another individual is now overseeing the final arrangements for the decedent. The complainant believes that this individual has committed fraud and finds that this individual named Gary has committed fraud and finds ways to allow individuals to appoint him as executor over their estate and take their money. Furthermore, the complaint states that this person is also a local banker. In response, the respondent states that the decedent's body was taken to the respondent establishment where he had a pre-need policy and would be covered by an insurance policy. The decedent asked the local well-known banker to act as the executor of his estate and made plans to be cremated and intentionally wrote his children out of his will. The complainant and her sisters turned against the executor and the respondent was stuck in the middle. Respondent states that the complainant asked the cousin, who was a funeral director in Kentucky, to take possession of the body, and that the respondent released the body to the cousin and charged nothing for the services rendered or for charges incurred while storing the body. We found a history in this case of 3 closed complaints and 1 dismissed complaint, and we're recommending that this matter be dismissed.
Move to accept.
Second.
Have a motion from David Neal and a second,
Mr. President.
From Rob Helms, and a second from Wayne Hinkle. All those in favor?
Aye.
Opposed? Motion carries.
Number 4 is case 2013-024-421. On Tuesday, July 9th, 2013, the respondent failed to inform the complainant when they were removing the remains of the complainant's son, as previously requested by the complainant. Complainant states that they brought clothes for the decedent and family photos, and that when they asked the respondent about the time of the cremation, the respondent replied that they should just pick a time and say it was done, which the complainant found this to be offensive. Assuming that the cremation would be first thing in the morning, the complainant planned a memorial for the decedent on Friday, July 12th, 2013 at 8 o'clock in the morning. On July 15th, the family loaded into the car after learning that the remains were ready to be retrieved. However, upon entering the establishment, the employee who assisted in the funeral arrangements informed them that she would have to take a look at the log to make sure that the cremation had actually occurred. Then the complainant's husband paid the final bill and took the cremains to the car. While reviewing the cremation documents, the complainant realized that the cremation actually took place on the 10th, and after the establishment received 1/3 down and before the complainant brought the decedent's clothes and family photos. The complainant cannot understand why they were not contacted about retrieving the remains earlier, and complainant cannot understand why they were led to believe that he was not cremated until later in the week. In this case, we received no response from the respondent, and we found 1 closed complaint for a previous history. And in this case, we're recommending a consent order with a $250 civil penalty for failure to respond and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Ms. Anita Taylor and a second from Rob Helms. All in favor?
Aye.
Any opposed? Motion carries.
Number 5 is case 2013-024-971. On October 3rd, 2013, a field representative conducted a routine inspection of the respondent establishment. A review of 5 contracts indicates that the respondent has been charging $225 for dressing, casketing, and cosmetology. However, the general price list that was in effect at the time reflects that a similar charge of $200 should have been imposed for those services. We found received no response from the respondent in this case, and found a history of 4 closed complaints and 1 open complaint. And we're recommending a consent order with a $500 civil penalty, which includes failure to respond and authorization for a hearing.
Motion to accept.
Second.
Have a motion from Robert Helms, second from Mr. Hinkle. All in favor?
Aye.
Any opposed?
All these people that's got the open complaints, is there any way they can't get an establishment license until they pay the open complaint? Take care of that open complaint?
I think that would have been only if the board had asked us to put that in the consent order. In that case,
Did they just do it every time then,
Right.
basically?
Yeah.
Okay.
Is that legal to do that?
I don't know. That's something I would have to.
Why don't you check on
To
that
check
for
on
us?
that
Because
and
there's
let
a
you
There's a
know.
lot
lot of
of,
open complaints.
there's a
Right.
lot of these out there.
Right.
Okay.
Did we complete?
Yeah, we
Okay.
voted.
Okay. Number 6 is case 2013-024-981, and number 7 is case 2013-024-982. On December 12th, 2013, a field representative conducted a routine inspection of the respondent establishment. Upon a random sampling of files, it was determined that one file pertaining to the decedent, Thomas Lee Littleton, lacked a cremation authorization form. And also, the field representative was able to locate a blank cremation authorization form in the file. In response, respondents number 6 and number 7 state that the cremation authorization form was mistakenly placed in another file, and that after that, respondents provided a copy of the form actually filled out. For respondent number 6, we found a history of 2 closed complaints and 1 open complaint. And number 7, we found a history of no prior complaints. And in this case, we're recommending for respondent number 6 a consent order with a $250 civil penalty and authorization for a hearing. And number 7, a consent order with a $250 civil penalty and authorization for a hearing.
Move to accept.
Second.
Have a motion from Ms. Sal and a second by David Neal. All in favor?
Aye.
Aye.
Any opposed? Motion carries.
Number 8 is case 2014-000881. On January 22nd, 2014, the board received a complaint filed against the respondent establishment. The complainant stated that they had not received a copy of their mother's death certificate after more than a month. The respondent informed the complainant that the hospital had yet to respond to their request for the death certificate, and the complainant then contacted the hospital and learned that the ER doctor notated in the decedent's file that the primary care physician would be responsible for signing the death certificate. The complainant believes that they were not treated fairly by the respondent and that they have been lied to for more than 4 weeks. In response, the respondent states that they typed up the death certificate and delivered it to the hospital. After making several attempts to contact the doctor who pronounced the decedent dead, the respondent learned that the doctor was actually an ER doctor and was unwilling to sign the death certificate. On January 22nd, 2014, the respondent was able to contact the primary care physician and obtain their signature on the death certificate. The respondent then attempted to contact the complainant to no avail, but was able to deliver the document to a family representative at that time. We found a history of 2 closed complaints, and we're recommending that this case be dismissed.
Motion to
Question.
accept.
Okay. I have a motion from Mr. Hinkle, second from Mr. Taylor. All in favor?
Question.
Oh, question, sorry.
The ER doctor, this is just for my information, this ER doctor refused to, was unwilling to sign the death certificate, and he pronounced this individual dead?
That's what they're alleging. That's what they're alleging. That's
Okay,
correct.
thank you.
Okay, I have a motion by Ms. Taylor,
Second.
second
Mr.
by Mr. Helm, Mr. Neal. Okay, all in favor?
Aye.
Aye.
Any opposed? Motion carries. I will say this, that's quite common. I mean, we run into it all the time in ER doctors, and, because most of them are staffed by a group. You know, they go to different hospitals, and one of them will not sign for the other one, even though it'll be 6 weeks before he comes back. And then they have to try to track him down. It has become a problem. All right.
Good to know that.
Next, we have several cases that we're representing to the board. Number 9 is case 2013-013641. Number 10 is case 2013-013642. Number 11 is case 2013-013643. Number 12 is case 2013-013644. And number 13 is case 2013-013645. And I've done things a little bit differently on this complaint since it's so long. I've put the response immediately after what the allegation is in this case. So on July 11th, 2013, the board received a complaint supported by 6 various affidavits or depositions encompassing the 5 respondents referenced above. Following a fire on April 17th, 2012, respondent number 9 continued to accept dead human bodies for cremation services with knowledge that the establishment lacked the proper refrigerated facilities to store these bodies, requiring proper refrigeration and not embalming. In response, respondents deny the allegations and aver that after the April 2012 fire, respondents transported or caused to be transported dead human bodies which were to be cremated to other cremation establishments. After the fire, bodies were sent to Phillips Robinson Memorial Crematory Lawrence Funeral Home, and West Harpeth Crematory. Next, for a time, respondent number 9 stacked boxes containing putrefying remains in an unrefrigerated back room at the establishment of respondent number 13. In response, respondents deny allegations that they stacked boxes containing putrefying remains in an unrefrigerated back room at the establishment of respondent number 13. Next, respondent number 13 had a refrigeration unit that only held 3 human bodies. For this reason, respondent number 9 had an employee move stacks of boxes containing dead human bodies into a small building or barn where the bodies remained for days, resulting in an overpowering stench of decomposing bodies. Respondents admit that respondent number 13 had a refrigeration unit that only held 3 human bodies. Respondents deny that any boxes of human bodies have ever been placed in the small building or barn at respondent number 13 for any reason other than for a period when a large cooler in an adjacent structure was used. Respondents deny that they ever left bodies unrefrigerated for days, and without admitting the allegations of this complaint, respondents acknowledge that bodies sometimes smell dependent upon the circumstances of death and the status of decomposition upon arrival to respondent's possession. Number 8, on occasion, respondent number 9 had employees place numerous boxes containing dead human bodies in stacks in a van for the purpose of hiding them from the state of Tennessee field representatives. Respondents admit that they transport human bodies in a van. Respondents specifically deny that they ever placed human bodies in stacks in a van for the purpose of hiding them from the state of Tennessee field representatives. Respondents further deny that they have intentionally deceived state of Tennessee field representatives and deny remaining allegations in this paragraph. Next, respondent number 9 moved dead bodies around on what employees called a church truck. As many as 6 or 7 boxes with stacked smoldering bodies were witnessed by an employee. Respondents deny stacking bodies 6 or 7 boxes tall, as the weight from the bodies would have caused the boxes to collapse. Furthermore, to stack the boxes that high would require heavy machinery, as the boxes would be about 14 feet tall. Respondents deny any insinuation that was intended by the use of the term smoldering bodies. And respondents state that the inspections are unannounced, therefore they would not have time to move bodies around prior to the field representative making an appearance. Next, respondent number 9 routinely substituted cheaper merchandise for merchandise specified in pre-need contracts. Respondents deny this allegation and argue that if respondents provided the customer merchandise, which was different than the merchandise specified in the pre-need contract, then the respondent so advised the customer, obtained their consent, and provided like kind and quality merchandise. Pre-need contracts often called for the purchase of Batesville brand caskets, which are generally regarded as the best available. On behalf of respondents number 11, number 12, and respondent number 9, respondent number 9 purchased and substituted less expensive Southern Craft brand caskets for the Batesville caskets without customers' knowledge, and then retained the difference in prices for their personal benefit. In response, respondent states that they deny these allegations, specifically that they engage in any business practices intended to defraud customers. Respondents admit that they sometimes give customers a casket which is different than the casket designated in the pre-need contract. However, that is only done with the customer's consent. Respondents argue that they may offer a different casket of like kind and quality if the designated casket is discontinued or that the casket company has gone out of business. Furthermore, the family of the deceased may choose a different casket, and respondents specifically assert that if the family of the deceased chooses a less expensive casket, the family may choose to be given a refund for the difference in amount or a credit to use towards other merchandise. And no respondent retained any difference in price for their own personal benefit. Next, respondent number 9 cheated customers by using names for caskets that were ordinarily employed by Batesville, such as Primrose. Respondents deny these allegations that they have ever cheated their customers in any way. Respondents admit that they name and rename caskets as is customary in the industry. However, respondents specifically deny that they engage in any business practices intended to deceive their customers. Next, respondent number 9 ordered cheaper poplar caskets, painted them with a cherry stain, and then sold them as though they were the more expensive cherry wood models without revealing the difference in quality or price to the customers. Respondents deny that they ever painted or stained caskets for any reason. They are aware that some casket companies make caskets out of poplar wood, which is stained a cherry color by the manufacturer. Otherwise, when a casket is displayed, a description of the material from which a casket is made is attached in accordance with the law. Next, respondent number 9 purchased inferior caskets from Tetrick in the Tri-Cities area of Tennessee, many of which were damaged and some of which had holes in the welds. Furthermore, respondent number 9 had a body shop they used to repair these damages, and cheaper caskets were substituted for more expensive models purchased by the families. In response, respondent admits that they made a one-time purchase of caskets from Tetrick in the Tri-Cities area, but deny any of the caskets were damaged or had holes in the welds. Respondent specifically denied that they substituted these caskets for more expensive models purchased by the families. Next allegation is that pre-need contracts often called for the purchase of Wilbert brand vaults, a Superior brand of vaults, or Monticello brand vaults within which to place caskets. However, respondent number 9 purchased and substituted Eagle brand vaults for the more expensive vaults without customers' knowledge. To carry out this scheme, respondent number 9 painted the cheaper vaults and placed liners in them to create the appearance of more expensive and requested Wilbert brand vaults. Respondent number 9 would then retain the difference in costs under the pre-need contracts for their personal benefit. In response, respondent admits that pre-need contracts often call for the purchase of Wilbert brand vaults or Monticello vaults are always superior to all other brands of vaults. Respondents deny that they purchased and substituted Eagle brand vaults for the more expensive vaults without the customer's knowledge. Respondents admit that they sometimes give customers a vault which is different than the vault designated in the pre-need contract, which only with the customer's consent, and they may offer a different vault of like kind and quality if the design vault is discontinued, the vault company has gone out of business, or the respondent no longer utilizes a particular company. Furthermore, respondents deny replacing liners in vaults and assert that if the family of the deceased chooses a less expensive vault, that the family may choose to be given a refund for the difference in amount or a credit to use towards other merchandise. Furthermore, respondent number 9 never retained any difference in price for their personal benefit. The next allegation states that from 1996 through 2004, the Batesville operated a program called Total Casket Protection. This was a form of insurance intended to ensure the family of decedent would have the particular casket they ordered, which often resulted in refunds at the time of delivery, which were to be returned to the purchasing family. However, respondent number 9 kept these refunds for personal benefit rather than tendering the money to the families. In response, respondents admit that Batesville operated a program called Total Casket Protection, but lacked sufficient information to admit or deny when Batesville operated the program. Respondents denied that the program was a form of insurance intended to ensure that the family of the decedent would have the particular casket they ordered, and specifically denied that rebates were to be returned to the purchasing family. Respondents argue that the program was a consumer program for the funeral home, providing an incentive for funeral homes to purchase Batesville caskets. Furthermore, Batesville guaranteed that the funeral home would get the casket at the time of need for the same amount listed on the pre-need contract. Next allegation states that on multiple occasions, respondent number 9 accepted checks as payments for funerals, then endorsed the checks, and then wrote off the amounts as bad debts without placing the funds in a trust so that they would be available when the need for the funds arose. Respondents deny that respondent number 9 accepted checks as payment for funerals, endorsed the checks, and then wrote off the amounts as bad debts without placing the funds in a trust so that no funds would be available for future need. Next allegation states that respondent number 9 instructed employees to place cash payments for services in an envelope and place the envelope in the respondent's desk drawer. Respondents deny that the respondent number 9 instructed employees to place cash payments for services in an envelope and place the envelope in that respondent's desk drawer. Next allegation states that respondent number 9 pocketed funds for funerals without placing them in the establishment account and marking them off as bad debt. In response, respondents deny respondent number 9 pocketed funds for funerals without placing them in the establishment account and marking them off as bad debt. Specifically, they deny it is a business practice to place money in the drawer. Next allegation states that respondent number 9 converted customers' refunds from pre-need contracts for respondent's personal benefit rather than refund the customer's money. In response, respondents state that the prices on the date of death are those charged under pre-need contracts. When the funds invested under a pre-need contract yield a return greater than the fair market value of the items and services purchased to be rendered under the contract. Respondent number 9 simply increased the cost in order to keep all of the money. Respondents deny. Respondent number 9 converted customers' refunds from pre-need contracts for respondent's personal benefit rather than refund the customer's money. Next allegation is that respondent number 9 sent fraudulent documents to Forethought via interstate wire transfer. Furthermore, respondent did so for the purpose of deceiving customers and depriving families of the refunds to which they were entitled. In response, respondents deny respondent number 9 sent fraudulent documents to Forethought via interstate wire transfer. Specifically, respondents deny that they converted customers' refunds from pre-need contracts for the benefit of the respondents or that they used any tactics to trick their customers. Respondents aver that the customers were given a refund when the funds invested under a pre-need contract yield a return greater than the current general price list for the items purchased and the services to be rendered under the contract. Respondents further assert that they sold merchandise for the price listed in their general price list, which is regulated by the federal disclosure requirements. Respondents deny respondent number 9 sent fraudulent documents to Forethought via interstate wire transfer, and specifically that the respondents deny that they created or forwarded any fraudulent documents, utilized wire transfers, or engaged in deceitful business practices. Next allegation states that on one occasion, respondent number 9 accepted a restored 1951 Ford motor vehicle with an estimated value of between $20,000 and $25,000 as a payment in kind from a husband and wife for their funerals. Furthermore, no funeral funds were placed in trust for these pre-need funerals, and the purported price of the 2 funerals was far less than the estimated value of the motor vehicle. Also, 2 contracts were drafted for the funerals and then charged off as bad debt. In response, respondents admit that respondent number 1 accepted a restored 1951 Ford motor vehicle but never had the car appraised, and therefore never admit nor deny that the allegation as to the vehicle's value. Respondents aver that the husband and wife were actually the grandparents of respondent number 9's wife, who were concerned about paying for the funeral and asked respondent number 9 if they would take the car as payment. Also, the grandparents asked that the car be used in their funerals, and respondent number 9 agreed to take the car in exchange for 2 funerals as a favor to his family. Furthermore, respondent number 9 took possession of the car and executed a sworn statement stating that the couple's funerals were then paid in full, and funds could not have been placed in trust because respondent number 9 never sold the car, as he was saving it to use in the funerals, and no funds exchanged hands in this case. Also, respondents denied the charge of the funerals being written off as bad debt, and respondent number 9 stored the car for years and has since returned the car to the family. Next, when a competing funeral home generously provided additional space to the respondents for embalming purposes after the April 17, 2012 fire, an assistant of respondent number 9 solicited business from a grieving family on the premises of the generous funeral home on the same day that they brought their deceased loved one to that establishment for services. Respondents admit that a competing funeral home generously provided respondents additional space for embalming purposes after the fire on April 17, 2012, but deny that any of the employees solicited business from a grieving family on the premises of the establishment. Also, respondents aver that the manager for respondent number 11 received a call from a price shopper who inquired about funeral services and prices. As requested, the manager met with the family at the location of respondent number 13, where they discovered that the family had also contacted competing funeral establishments, and respondents deny solicitation of any kind took place. Next, respondent number 9 knowingly submitted falsified apprenticeship forms to the state of Tennessee on behalf of the respondent's daughter. These falsified documents included quarterly reports and records of time not actually spent with the daughter's sponsor. In response, respondents denied that respondent number 9 knowingly submitted falsified apprenticeship forms to the state of Tennessee on behalf of the respondent's daughter. The complainant who provided this information worked primarily as an embalmer at the respondent establishment and waited on very few families during the time these allegations took place. Furthermore, the daughter of respondent number 9 worked primarily under respondent number 9 and the manager of the establishment rather than with the complainant in this case. The next allegation states that after respondent number 9 accused the complainant of violating a non-compete agreement, respondent number 9 instructed an agent of respondent number 2013 to attend the May 8th, 2013 burial services, where complainant was to say a prayer as previously expressly requested by the decedent. This agent took a photograph of the complainant just as the mourning family bowed their heads to pray and just before a family member was to read a passage. Furthermore, the family members witnessed this profoundly disrespectful conduct, and the decedent's husband cries every night because of what occurred at his beloved wife's funeral. In response, the respondents admit that they filed suit against the main complainant, in this case for violating a non-compete agreement. Respondents deny that they instructed an agent of respondent number 13 to attend the May 8th, 2013 burial service. And respondents aver that an agent of respondent number 13 always attends services which occur at that cemetery. We found a history for respondent number 9 of 1 closed complaint. Respondent number 10, we found no prior complaints. Respondent number 11, 1 dismissed complaint and 10 closed complaints. Respondent number 12, we found 1 closed complaint. And respondent number 13, we found 1 closed complaint and 1 open complaint. And in this case, for respondent number 9, we're recommending a consent order with a 1-year suspension and authorization for a hearing. Number 10, we're recommending a consent order with a 1-year suspension and authorization for a hearing. Number 11, a consent order with a $3,000 civil penalty and authorization for a hearing. Number 12, a consent order with a $3,000 civil penalty and authorization for a hearing. And number 13, a consent order with a $3,000 civil penalty and authorization for a hearing.
I asked you to read that all again.
Mr. Chairman,
Motion to accept council's recommendation. He's done too much
excuse
work.
me, Mr. Hinkle.
Oh, I'm sorry.
She's already talking.
Mr. Chairman, I
You just couldn't hear.
wish the record to reflect that I'm recusing myself from consideration of these items.
Is respondent number 9, is that consent order with 1 year is that suspension of license?
Yes.
Okay.
Funeral directors and embalmers, funeral directors.
Number 9 would be the funeral directors, and number 10 would be the embalmers.
Okay.
It's the same person?
Same person.
Okay. And number 11 is,
An establishment.
and number 12 is,
An establishment. Number 13 is an establishment as a crematory.
why, of course, this may be, I have a question. The penalty for this almost seems very minute. Seems like it should be much higher from, everything.
Well, it is ultimately left up to the board to make that determination about what's the proper punishment in this case. We felt this was appropriate, but obviously it's up to the board to make that final determination.
But you feel comfortable with these? You feel comfortable with these fees?
Yes.
Okay. We got a motion?
Are you making it?
I'm making it.
Okay, have a motion from Mr. Hinkle,
Motion to accept council's recommendation.
Second.
second from Rob Helms. All in favor?
Aye.
Any opposed? Motion carries.
Somebody's been busy.
Number 14 is case 2013-017-481. A consumer recently appeared at the complainant's place of business to check on the status of a pre-need direct cremation arrangements they made in December of 2008. She presented the complainant with a paid cash receipt in the amount of $1,515 signed by the respondent, a statement of funeral goods and services selected, a change of policy, certificate and annuity ownership to the Forethought Trust form, and the group enrollment form to Forethought. She advised that at the time the pre-need arrangements were made, that she paid cash to the respondent, who folded the money and placed it in his pants pocket. The complainant has no record whatsoever of this transaction and confirmed with the consumer that she had not received any policy information in the mail from Forethought Life Insurance Company. The complainant contacted Forethought and other carriers utilized by it during this time frame, and again found no record of this transaction. The complainant acknowledged the payment made directly to the respondent and committed to honor the contract. In response, the consumer appeared at the complainant funeral home in December of 2008 and paid cash in the amount of $1,515 for pre-need direct cremation arrangements. The cash was delivered to the respondent, who then drafted and provided the consumer a paid cash receipt, a statement of funeral goods and services selected, and a change of policy, certificate, annuity, ownership to the Forethought Trust form and the group enrollment form for Forethought. Respondent denies any allegation, insinuation, or accusation that he acted illegally, inappropriately, or in a manner unbecoming the profession in a manner whatsoever. Complainant fails to actually accuse respondent of anything. The complaint is vague and ambiguous and leaves it unclear what is being alleged and who the complainant is blaming for the apparent failure to properly store records and comply with applicable laws and regulations. The complaint only states that the complainant believes it is appropriate to report this matter to the board because respondent was involved in the transaction, merely insinuating and leaving it to the imagination of the reader to conclude that the respondent has done something wrong. Complainant is just likely to be responsible for these actions, and one may easily conclude that respondent delivered the cash and documentation to the owner as he was instructed to do, and the owner failed to process the pre-need order and cash the properly filed documentation. There's no express allegation in this complaint, and it was standard business practice at complainant establishment during respondent's employment to do exactly what is described in the complaint as far as drafting documents and accepting cash from clients. The respondent was then instructed to deliver the contracts and cash directly to the owner and was advised that the owner would take care of it from there. Whether the owner properly processed and stored the documentation and deposited cash from the point of delivery is unknown at this time, and the complainant is to blame for the failure to properly file the pre-need paperwork, not the respondent. Respondent created and executed all necessary documents and provided copies of them to the consumer, just as he was supposed to do. And the complainant says that the complainant does not have a record of the transaction at this time, but does not affirmatively state respondent failed to ever provide a record or the cash to the owner at any time. What the owner did with the documents and cash and why he failed to process them or invest the cash is left to the owner to explain. Acceptance of cash for services was common practice and openly encouraged. When the owner first hired respondent, the first thing the owner told the respondent was checks are fine, but cash is divine. The owner would routinely come to the respondent and tell him that he needed cash and he did not care how he got it. Had the respondent not provided the appropriate paperwork to the consumer, it may have been more difficult to convince complainant to uphold his end of the contract. To the extent that the complainant communicated any of the false allegations now asserted against the respondent in this complaint, the complainant is possibly liable for slander and tortious interference with prospective business relationships, but those allegations are outside the jurisdiction of this board. Respondent denies all of these allegations of impropriety and respectfully requests this complaint be dismissed. We found a history of 2 closed complaints and 1 open complaint, and we're recommending that there be a consent order sent with the voluntary revocation of license and authorization for a hearing.
Mr. Chairman, I ask to be recused from consideration of this complaint.
Motion to accept council's recommendation.
I have a motion from Mr. Hinkle.
Question.
Question?
Tell me what you're really asking for voluntary revocation of the license. I mean, asking for that individual to just turn in his license voluntarily?
Well, we sent a consent order, and basically we are asking for a revocation of the license, but this gives them an opportunity to just basically relinquish the license on their own. And
Indefinitely?
Indefinitely. I mean, they can always come back and submit an application for a new license, but that's what we're asking for now, and if they don't do that, then they have the right to a hearing.
What's the likelihood that they'll do that voluntarily?
It happens on occasion, but not very often.
It's the same person on December 28th where the license was suspended for 1 year?
I can't provide that
Okay.
that information.
Okay.
Is there a motion, I think?
I have a motion from
I'll
Mr.
second.
Hinkle.
I'll second.
Second from Rob Helms. All in favor?
Aye.
Any opposed? Motion carries.
We have about a 5 or 10 minute break, please.
Yes.
Thank you.
We'll have a break right now for 5 minutes. All right, Mr. Benton, if you will, proceed.
Okay. Thank you, Mr. President. Number 15 is case 201102641. The complainant's husband passed away on August 1st, 2011. Respondent number 15 performed his cremation, and his ashes were supposed to be placed in a black heavy plastic container to be mailed to Orlando, Florida. The ashes were supposed to arrive in 4 to 5 days, but respondent number 16 stated that someone forgot to mail them. It took approximately 2 weeks for the ashes to arrive at that point. When the church in Orlando opened the box, they found ashes in a plastic bag without the proper container. The church called the decedent's mother to come retrieve the ashes, as the church could not place the ashes in a vault without a container. So the decedent's mother was forced to purchase an extra urn at that point. The complainant then called respondent number 16 and told him that the ashes, explained to him about the ashes at the church, and respondent number 16 stated that someone must have tampered with the container. Also, the complainant states that her husband had an insurance policy and that the complainant keeps receiving phone calls from the insurance company stating that they need a certified death certificate. Complainant called respondent number 15 and found that they had yet to send the insurance claim, which had been in the respondent's possession for a month. The complainant states that respondent number 16 informed her that they had not heard anything from the insurance company regarding paperwork, and that the complainant called the insurance company again who informed her of the particular forms that were needed from the respondents at that time. The complainant continued attempts to contact the respondents, and her calls were not returned, so she filed this complaint. Shortly after filing the complaint, respondent number 16 came to her residence to fill out the paperwork. Complainant called the insurance company and was informed that the company received the death certificate but not the form necessary from the respondents. Respondent states that the statements regarding the delay in mailing the cremains were correct, and that the cremains were not mailed until August 17th, 2011, and arriving in Orlando on August 22nd, 2011. Respondent states that the cremains were mailed in a plastic bag with a temporary container of cardboard, not the container the complainant believed that they would be mailed in. Respondent states that they used both cardboard and plastic containers, and that the respondent states that the only way the church would have known the cremains were in a plastic bag would be if they opened the container. The respondent states that they always seal cremains in a plastic bag inside a temporary container, and the idea that the respondent mailed the cremains in a plastic bag alone would not be correct. As for the insurance policy, the respondent states that they offered to file the paperwork for no charge and took an assignment on the amount owed the funeral home through express funeral funding. Respondent states that the insurance company mails claim forms, and they could not be obtained via fax or online. Furthermore, the respondent states that they received the necessary forms and called the complainant on September 12th, offering to drive to her house to fill out the paperwork. The documentation was sent to Express Funeral Funding on the 13th, and the respondent contacted the company following the complainant's call on the 21st. To which the insurance company stated that all documents had been sent to the insurance company to finalize the claim. Respondent admits that the timing of events was not good, and that the respondent will no longer mail cremains in cardboard temporary containers. All will now be mailed in a poly temporary container. We found a history of one closed complaint not related against respondent number 15, and number 16 had no prior complaints. Previously, we recommended a consent order with a $250 civil penalty and authorization for a hearing against number 15, and a consent order with a $250 civil penalty and authorization for a hearing for number 16. Our new recommendation is that respondent number 15 has actually signed their consent order and paid the civil penalty in this case. However, we're recommending that number 16's complaint be closed. This individual is no longer licensed as a funeral director, and their license is now invalid.
Motion to accept.
Second.
Have a motion from Ms. Taylor, a second from Mr. Hinkle. All in favor?
Aye.
Any
Change
opposed?
that respondent's number 4 to 16.
Yeah, yes, sir.
Okay,
I'll do that.
thank you.
All in favor?
Apologize for that. Let me see.
Aye.
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 Okay. Any opposed? Motion carries.
Number 17 is case 2011-031-241, and number 18 is case 2011-031-242. On November 23rd, 2011, a field representative conducted a routine inspection of the respondent establishment. During this time, during the inspection, it was determined that the respondent had a crematory service on the same property as the funeral establishment. On the website, they advertise about animal cremations and the services that they provide, along with the human crematory and its services. The crematory service has an animal retort that has been added since the last inspection performed in 2010. The animal retort and human retort are housed in the same building with no separating walls and only one refrigeration unit. The field representative learned that the refrigeration unit was not used on the animals. However, nothing prevents this from happening as they are side by side, parallel with no wall and approximately 3 feet apart. Furthermore, during the inspection, it was determined that respondent number 18 had a crematory service on the same property as the funeral establishment, and on the website they advertise about regarding animal cremations and the services that they provide, along with the human crematory and its services. In response, respondent states that the funeral business is under attack from many angles, the most disappointing of which is the funeral board. Archaic regulations stifle growth and certainly do not protect funeral directors or the public from those seeking to dismantle a business based on trust and tradition. As a businessman, the respondent has extended their base of services so that they may assist those in need with the full array of services connected with the loss of a loved one, human or pet, and whether the family's choice is burial or cremation, including all merchandise from cemetery lots to markers and all necessities in between and after the death. The Pet Care Services service handles the final disposition of the extended family pets. Pets can be anything a person loved and cared for, and therefore willing to pay to bury and cremate. Losing a pet can be as devastating as losing a human loved one. Housing the pet retort in the same building as the human retort was a practical decision, as was locating the pet cemetery and the human cemetery, though that was a decision made long before the respondent purchased the cemetery. Proximity is only irrelevant to an unethical person, and the respondent states that they are ingrained with a code of ethics and want to allow them to commingle the remains of humans and animals. Both retorts are clearly marked and equipped for each process is separate. Pet refrigeration is in another building but is rarely used because pets are usually cremated immediately upon arrival. This violation is encouraging the respondent to commit fraud by hiding a service that they provide. Building a wall within a building to physically separate the two retorts is an option, but ventilation and employee safety issues will need to be researched. Furthermore, and this is actually a previous violation that was found as well, as for the violations regarding business cards, the titles were not listed on the cards because one individual has multiple responsibilities within the business, and the other person had their own cards printed when they retired from the business. Business cards will be reprinted with office manager as the title on the card, and the other person had the name of the funeral establishment removed from their card following retirement. In that case, that part was deleted from the original findings in the original complaint I just read, but they have corrected that issue with the business cards. And so we found, for respondent number 17, we found a history of one closed complaint with related TCA violations, and number 18, we found 2 closed complaints with issues not related. The original recommendation for number 17 was a consent order and a letter of instruction stating that in the event that individual wishes to continue providing pet cremations on the same premises as human cremations, the following changes should be made within 90 days of the receipt of this letter. And similarly, respondent number 18 received a consent order and a letter of instruction stating that in the event you wish to continue providing pet cremations on the same premises as human cremations, then the following changes should be made within 90 days of receipt of this letter. For the new recommendations, for number 17, we're recommending that this complaint be closed, as counsel discussed these allegations with an expert in the funeral law, and this individual believed that the allegations were very unlikely to be successful. And the same for number 18, we're recommending this case be closed, as counsel discussed these allegations with an expert in funeral law, and the expert believed the allegations were very unlikely to be successful.
Make a motion we accept.
Second.
Second.
Have a motion from Mr. Neal and a second from Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries.
Thank you, Mr. President.
Let me ask a question. Does that mean that in the future you can put a pet crematory, and a regular in the same building without a wall separating after this what you said here at the end?
I think it's really, it would be up to the board, that this individual believed that based upon the way that our statutes and our rules are currently stated, that it would be unlikely that an expert in funeral law would testify that was a violation. But, you know, as we've stated before, it's up to the board to determine whether or not, you know, they want to pass new rules or, you know, new rules in that
I mean,
case.
this
or
has come before us before, and we've said
Right.
it has to be a wall there.
Right.
So this kind of sets another precedent here.
But now, the wall was only a suggestion.
That's correct.
It was just a suggestion, so I don't think we have the power to impose a civil penalty on a suggestion that's not followed, correct?
Well, you would have the power to impose a civil penalty in a complaint that you would have the power to impose a civil penalty in a complaint that's filed against an establishment such as this. But you know, if we were to bring the complaint to you, you can assess a civil penalty for that. But whether or not, you know, they were to agree to it, and then we were to bring it to a hearing, and then you all would determine there's a violation, and you know, that would really be up to you all to make that determination during that period of time.
Yeah, I understand that part, but what I'm saying is we've knocked this wall around and we've done all this, you know, before, but really and truly, we're making a suggestion. Wasn't that what we've been doing about the wall?
I believe that was it was determined that was a suggestion at that time, and then the field representative would come back out and make an inspection, and then, you know, if we determined that they weren't following the rules and statutes at that point, if they hadn't made any changes, then we would likely open another complaint in that case. But
President, Mr. Chick is here, if it's okay to move to the presentation of his consent order for the board's
All right.
consideration.
We thought we was going to let
Mr.
him
Cheek?
come last.
Get that lapel mic so you get picked up on the lay it back up there if you don't care. I'm sorry, I laid it over there later.
Okay, I've got a consent order here that was the consent order was previously offered to Carl Points.
May I ask to recuse myself from this consideration, this consent order?
Yes, so noted. All right, Mr. Chief, you can continue.
The stipulated finding is a fact order that he had, in November 28, 2011, the complainant's father was in the hospital, and that the respondent had contacted the the decedent's wife was contacted, the decedent's daughter was contacted, that the respondent solicited bodies, and I think he was offered $1,000 civil penalty. He didn't accept it. Prior to filing charges, I offered him $2,500, and he's agreed to that, and he's paid the money. So I submitted to the board and ask that you approve that.
Accepted.
Should I read this before we vote on it, or is everybody kind of familiar with?
There's one each person has one in their,
Oh, okay.
on their,
On the
iPad.
pads.
On the
Battery's
iPad.
dead on my pad.
Yeah,
I'm-
everyone will.
Yeah, it's okay. Go ahead. That's all right.
Here,
You're
we
fine.
good.
I can read it right there.
There's that consent order.
That consent order on the iPad.
Open complaint? No.
what that's under?
I'm sorry, it may not be on there. I may have told you something incorrect.
I don't see it, but it could be under some of the name.
Can I just read this then? I think
Public Act.
This matter comes before the Tennessee State Board of Funeral Directors and Embalmers, herein call the board, based upon violations alleged in a consumer complaint, Carl R. Points, herein call respondent, voluntarily enters into a consent order to avoid formal charges in a contested case proceeding with respect to the matters described here within. Can I go forward to the stipulated finding of facts? Would that be okay?
President, anything you
Okay. Respondent conducted business at all times pertinent while in possession of a valid license, having been issued license number 5122. On or about November 28, 2011, the complainant's father was in an intensive care unit of a local hospital, and the respondent stopped by the hospital to offer his condolences and hand out business cards to several family members. Later the same day, the respondent contacted the complainant's mother at home to once again offer his condolences to the family. On November 29, 2011, the complainant's father passed away, and the respondent attempted to contact the complainant's mother at home. However, the complainant answered the phone, and the respondent informed her that he was no longer employed by Williams Funeral Home in Columbia, Tennessee, but he would be working with Heritage Funeral Home and Williamson Memorial. Stipulated conclusions of law. Respondent admits that the aforementioned acts and conduct of the respondent, as previously described herein, constitute a violation of the following statute and the rule. Tennessee Code annotated 625317B3B. In addition, the board may refuse to grant or may suspend, revoke, or refuse to renew any license granted for the operation of a funeral establishment, or to any funeral director or embalmer under this Chapter 4, solicitation of dead human bodies by the licensee, assistant employees where the solicitation occurs and the death is imminent, provided that it shall not be deemed to prohibit general advertising. Now, therefore, in order to effectuate respondent's desires and intention, respondent shall pay a civil penalty amount of $2,500. Respondent shall comply with all statutes and rules governing funeral directors and embalmers in the state. The board shall seek no additional sanctions against the respondent by reason of the violations admitted herein. The respondent acknowledges the board's right to seek additional sanctions against the respondent for any future violations. Respondent acknowledges, understands, and agrees that this settlement in no way binds any other agency, division, Department of Public Subdivision of the state of Tennessee relative to any factual allegations cited herein. Respondent understands that respondent has a right of a hearing under the Uniform Administration Procedures Act, Tennessee Code annotated Title IV, Chapter 5, but respondent is waiving that right in order to enter the settlement. This order shall have no effect unless accepted by the board. Should the order not be accepted by the board, it is agreed that the presentation and consider of this consent order in no way prejudice the board from further participation in either formal or informal resolution of the matter. So this is executed 21st day of February 2014.
Motion to accept.
Second.
Have a motion to accept from Mr. Hinkle and a second from David Neal. All in favor?
Aye.
Any opposed? Motion carries.
Mr. President, would it be appropriate this time for me to submit a final order to you?
Yes.
In the case that once again, I didn't make a
You need a motion for this?
Well, I think this is just
You just,
what's already been done.
yeah.
Is this suspension effective today? Is that what this
It's
is?
effective, when the order becomes effective, which will be when I file it with APD. I hope it'll be tomorrow.
Okay. You need to sign that.
She needs to sign all these for you.
No, sir, just one.
Thank you. I
We
appreciate
might give
that.
this one to Mr. Breville.
Okay.
I appreciate that.
There's one other thing the board might want to hear. I don't know if the board has done it lately, but there's a provision in the UAPA that says the board can select one individual that will hear a petition for stay or petition for review. Instead of the whole board have, the respondent has the right to file a petition for reconsideration, and a petition for stay and all that. So as opposed to, if that happened, instead of the entire board having to gather, the board could designate one person that's gonna make that call. You can do that or you don't have to, but I was just throwing that out there in case you wanted to do that.
I don't
Be
think that's,
preferable that it be the,
I don't think that's gonna happen. I believe we all wanna be here, don't we?
Okay, well,
I mean, I'm just speaking for myself.
Well, I don't think I could because
No,
I
I
you
don't.
know,
I think it'd be appropriate for Ms. Taylor
Ms. Taylor.
to assume that in case that comes up, since she chaired.
But this,
she would have to be physically present, right? She's gotta come from
I'm
Chattanooga.
misunderstanding what he's saying.
Have we done that in the past?
I think so. I think that the board in past times, because go over what you said might happen so everybody has a clear
Well,
understanding.
What could happen is they have, the respondent can petition for reconsideration, is one thing they can do.
Like on this.
And if the board doesn't respond to it within 20 days, it's automatically deemed denied. So that can be a problem because that 20 days might run before you guys even get back together. So instead of having to gather you on a telephone conference call, the boards can just designate one person that will answer a petition for reconsideration or petition for stay. In other words, you could have one person, you could say, okay, we take a vote now that Ms. Taylor will handle any petition for a stay.
Is that for Mr. Lindbergh?
just for that
Okay.
case.
Anybody, or you can
Yeah.
vote just with regard to that one or in general.
It would prevent having to squirm at the last minute to get a teleconference set up, if that should happen. She would if you selected Ms. Taylor, then she would make the decision for the board.
Okay. I think it needs to be on an individual basis for this particular case, and then because each case is different.
Okay.
But I think definitely she should be able to make the decision.
And all she would be able to do would be to deny the petition or to, I mean, it's not like she's gonna be able to reverse the board's decision. You know, all she could do is agree to review it, and then when you get back together, you can.
But
Just
with
be
it,
deciding whether or not you think all the rest of us would let him have an appeal.
In other words, they would appeal it
Let them
saying,
appeal, and you
you
say,
know,
well,
we
I don't think-
overbroached in other words, his immoral act was not in the regard to handling a funeral. This was a personal matter, so therefore should not have been board.
Why don't we just stay with what we need to do is to designate instead of arguing the case again?
Maybe I should just.
No, I think once they're clear, what would the motion need to be, Mr. Chick?
That in the event that an appeal and/or a petition for stay is filed, that we will designate board member Anita Taylor to.
Well, what if she weren't available? Can you say that a member of the board could be contacted? Or does it have to be a specific person?
We would need to select some particular members.
Could it not be the vice president?
It could.
Just instead of, I mean, if we're going to do this, then each year, when your board changes, you'd have to put another name in. So if we just say vice president, would that not?
Oh, yeah, I believe that would do it. Unless it happened to be on the next contested case, the vice president had to recuse him.
Why don't we just do it per this one case?
Yeah.
I think that'd be the simplest thing.
Now, let me ask one question. Okay, she denies it, then what happens? Nothing, or do they go to another court?
Nothing, they can file a petition for appeal to this board, petition for review, or they could go to Chancery Court and file it. But what the respondents do sometimes is they'll say, I'm appealing this. In the meantime, will the board please stay or hold off on the judgment? They'll want you to enter a stay so that his license is not suspended while he does his appeal. And that's what, it's good to have one person that can say yes or no.
But I would still have the opportunity to get the feel of the other board members, correct? I mean, call them? No, I would just, oh. Okay.
If you're more comfortable, I'm okay.
With what happened today, that he gave the judge for Chancery Court, I'm sure that's the next step if I would interpret that. You remember when he presented a document and said it to be item number so-and-so, and you said, well, that's only if it goes to court, it has no bearing here. And he said, I'd like it part of the record. It sounded to me like it. Anyway.
That's up to you, and you don't even have to decide it right now. I just wanted to throw that out there.
Do I have a motion?
Ms. Taylor, would you be willing to serve? I mean,
Sure,
before we do this
I
motion?
would.
Okay.
I would.
Throw you under the bus,
Right.
like, oh, God.
That's all right.
Gotta come up
I'll
here.
make that motion.
Second it.
You got a second?
Okay, I have a motion from Mr. Ham, second from David Neal and Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries. Ms. Taylor will be the spokesperson.
Thank you.
He's up to something. He's up to something. I know him.
President, I would suggest you go back now and start this so we don't miss
Okay.
anything.
We'll start the meeting now.
I do the minutes.
Yeah. Because there are 4 sets of minutes, we're going to review each set separately and vote on them separately. So if you will review the, if you want to review all of them, and we'll still vote on them separately, or do you want to do them one at a time?
We need to start with January 3rd.
No, actually.
December.
December
Where
the
is
On the
it?
10th.
left, on the
Excuse
left.
me. Okay, I was looking at row 1.
Here.
Third one over.
Make a motion, we accept the minutes as written.
Second.
Have a motion from Mr. Neal and a second from Mr. Helms on the minutes of December the 10th. All in favor?
Aye.
Any opposed? Motion carries. Next, we'll review the minutes of January the 3rd.
Make a motion to accept.
Have a motion from Ms. Taylor,
Second.
second from Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries. Next, we'll review on January the 14th.
Move to accept the minutes as presented.
Second.
Have a motion from Ms. Sal, second from Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries. Now we'll do the minutes from February the 11th, the board teleconference meeting.
Motion to accept the February 11th minutes
Second.
as submitted.
Have a motion from Mr. Hinkle, second from Mr. Helms. All in favor?
Aye.
Hill.
Niels, excuse me. Y'all gonna have to change your voice or something, or I'm gonna have to get a hearing aid. All in favor?
Aye.
Any opposed? Motion carries. Is the legislative update, I notice there's no one left. Are you giving that?
Well, Greer Kelly, who is the legislative liaison for the department, was going to be here to do the legislative update and the Sunshine Law presentation. She and I have texted back and forth during the formal hearing, and she is involved in another matter at this time and can't come, so she's asked me to give an update. And basically, if you go back to your minutes of January the 14th, on page 20 of those minutes, House Bill 1380, which, as introduced, affects the requirements for the inspection of funeral establishments presently enforced pursuant to board rules. It authorizes unannounced inspections of establishments by a licensed funeral director and embalmer acting on behalf of the board. That bill is still pending and working its way through the legislature. House Bill 0250, which prohibits certain licensees in the funeral homes and funeral-related industries from affiliating or engaging in other arrangements with certain healthcare institutions and organizations. It's my understanding a form of that bill, maybe an amendment, has passed. So that one, those two are the main ones. You know, the removal service legislation was passed last year, and that's been enacted. So that was part of this General Assembly, the 108th General Assembly, but that's already passed. It's already in law. So basically, the other thing that's left and still pending is House Bill 1380, but it's my understanding that's working its way through. And I think that Ms. Kelly will probably come to your April meeting maybe and do the sunshine presentation. I mean, Mr. McDonough can give you the high points of that, but basically everything you do has to be out in the public, and they'll caution you about not sending emails to each other and making phone calls or making, talking about things when two or more of you are together. But she asked me to do this, so that's the, if you've got any questions, I'll be glad to answer them or send the question to her for her to respond to later.
All right, next be rules and rulemaking hearing. Mr. McDonald.
Thank you, Mr. President. As you will recall, I believe we previously discussed Public Chapter 122, which requires the regulatory boards to establish procedures, which basically expedites the process for individuals who are coming from out of state, traveling from out of state, coming into Tennessee. And the purpose of that is due to their spouse being in the military. This is the military spousal legislation, and in Section 2 of the statutes, it talks about military spouses, and it states that an individual who's certified or licensed to perform services in the state other than Tennessee, their spouse must be a member of the armed forces, their spouse must be subject to military transfer to Tennessee, and the individual who is licensed left employment to accompany their spouse to the state of Tennessee. Furthermore, the individual may be a former member of the military. The individual who's a member of the armed forces carries a license or certification in a state other than Tennessee that applies for a license or permit in Tennessee within 180 days of retiring from the armed forces, receiving any discharge other than dishonorable discharge from the armed forces, or being released from active duty into a reserve position here in Tennessee, and that's also under Section 2. And if you'll move down to Section 4 in the Public Chapter 122 that deals with education, and this allows the board to accept military education, training, or experience completed toward the qualifications to receive the license or certification if the board determines that it's substantially equivalent to the standards of the state. And finally, Section 6 deals with active duty personnel and their license expiring while they're on active duty. This states that if the license, certification, or permit expires while an individual is on active duty status, the individual is eligible to renew the license, certification, or permit upon release from active duty without payment of late fees or penalties, and also obtaining continuing education when circumstances prevented obtaining credits and waiver request was properly submitted, or the person performs the occupation as part of military duties and provides documentation, or performing any other act typically required for renewal of license or certification. The renewal shall be permitted up to 6 months from the release date from active duty, and the individual shall provide supporting documentation evidencing activation as may be required by the board. And all of this is to say that when the legislature adopted this and passed Public Chapter 122, basically it requires this board to come up with rules that will enable applicants and licensees in other states, if they meet these requirements, to be licensed by this board in a expedited manner. So basically what we're here to do today is to get permission from you all to move forward with the rulemaking process, and that they've asked me to come back before you today to obtain that permission.
Motion.
Yes, that would be preferable.
I'll make that motion.
I second it.
Then we'll get the name mixed up.
I have a motion from Mr. Helms and a second from Mr. Hinkle. All in favor?
Aye.
Any opposed? Motion carries.
This is for the next discussion topic.
I was gonna, hey, he gave me this, I signed it. I think he needed it.
What I just handed out, it states in there, this pertains to the rulemaking meeting that was held back in November of 2012. We've had further discussions with the AG's office about this, and they've asked for us to make a few more changes to the economic impact statement before we can send this over to the Secretary of State's office. And so I'm going to read the economic impact statement, and then at that point, assuming that you all agree with it, I'll just need a motion and have you all vote on adopting that as the board's economic impact statement. Number one, regarding types of small businesses and estimate of the number of small businesses directly affected. Funeral establishments would be affected by these rules. Tennessee has a total of 572 funeral establishments, approximately 450 of which could be considered small businesses. Those establishments will be affected by these rule changes as they employ some of the 3,108 licensed funeral directors and embalmers that will be affected by these rules. Number two, projected reporting, record keeping, and other administrative costs. There's Answer, there is no foreseeable alteration in small business reporting or record keeping that will result from the promulgation of these rules. Number 3, probable effect on small businesses and consumers. Answer, these rules should have a positive effect on both small businesses and consumers, specifically reducing renewal fees for funeral directors, embalmers, and crematory operators, and increasing the fees on reciprocal licenses to make them comparable to in-state licensees should have a positive effect on small businesses and therefore also on consumers. Number 4, less burdensome, intrusive, or costly alternative methods. Answer, the proposed changes to the existing rules are minimally burdensome and intrusive to small businesses. Number 5, comparison with federal and state counterparts. Answer, there are no federal and state counterparts to the issues addressed by these rules. And finally, number 6, effect of possible exemption of small businesses. Answer, an exemption of small businesses from the aforementioned requirements could be a detriment to health, safety, and welfare of the citizens of Tennessee.
Motion to approve.
Second.
Have a motion from Mr. Hinkle, a second from Ms. Sal. All in favor?
Aye.
Any opposed? Motion carries. All right, I believe next on the agenda be administrative matters, Mr. Robert Gribble.
Thank you, Mr. President. The first thing is the report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of January 14 through March 10 of 2014. You have the establishment and those individuals listed there before you. There are no closed establishments to report since the previous board meeting. Disciplinary action report. You have a report in front of you, the consent orders administratively accepted and approved by the Executive Director pursuant to the Board authority for the period of January 1, 2014 through February 28, 2014. And the last thing I have to report to you is the open complaint report. We're showing a total of 99 complaints. 8 of those are against funeral directors and/or embalmers, and 91 against funeral establishments. Mr. President, that concludes my report.
Right. Next will be acceptance of quarterly report.
Mr. President, I need a motion to approve.
Oh, excuse
A
me.
motion.
Motion to accept
Sorry.
Mr. Gribble's reports.
Second.
Second.
Okay, second by Mr. Neal and Ms. Taylor. All in favor?
Aye.
Aye.
Any opposed? Motion.
Next item, Mr. President, the attorney representing Mr. Crossland called yesterday and left a message for me and asked that his client be removed from the docket today. This was where they were seeking an exception. Remember, back in November, you had 2 people to come before you that filed late quarterly reports. This was another instance of that. The attorney asked to be removed from the docket and said, should he desire to come back, that he would let us know. And I forwarded that message to Mr. McDonough so he could hear it as well. So I don't know what, I assume they've decided to take it that the report was filed late and it's not going to be accepted, or the guy is no longer working in funeral service and he's not interested in his apprenticeship. I don't know. I just got a message from the attorney yesterday, and of course the agenda was already printed and approved at that time. And you have no establishments to come before you.
Ready? Is there any new business to come before the board? Is there any new business to come before the board?
No.
Is there any new business to come before the board? I'll accept a motion to adjourn then.
Motion to adjourn.
Have a motion to adjourn by everyone. All in favor?
Aye.
Meeting adjourned.
Sit still.
Everybody sit still.
Everybody sit still.